Last week, in the federal court in Pensacola, Florida, a motion to vacate was sent in and received by the court on the 31st.
10:31.
Should be 10/31, yeah. So they got the motion. They have 30 days to answer it. Motion to vacate means undo the whole case. It didn't happen. They missed first base. For the record, I'm healthy, I'm happy, I'm not suicidal, I'm accident-free for many years. I drive vehicles that have no mechanical problems. I take vitamins, and I plan to live to be 100 or die trying. I have maintained my innocence since day one of this unjust case. I did not commit any crimes for them to put me in prison. And this motion to vacate, we're going to read the whole thing right now on the record. And I want you to copy this, because this may be deleted by YouTube, and spread it everywhere. Save it in 1,000 safe places and give it to everybody. It's going to be, all this is going to be posted on Kent Hovind official. I know, on Kent Hovind is innocent. Let's see.
Kent Hovind is innocent.
Kent Hovind is innocent.
Hello, Kent.
Hey, Paul. I'm explaining that the court just received about 5 days ago the motion to vacate. What this means is they would have to go back and vacate the case. Let me give a quick synopsis, and then I'm going to read it. Do you have it in front of you there? 'Cause I'm going to ask you.
Yeah, I do.
Okay. John David Roy Atchison was one of the U.S. attorneys on my case that helped put me in jail and seized all the church property. He later then flew to Detroit to have sex with a 5-year-old and got arrested and hung himself in jail. You can Google John David Roy Atchison. Pastor faces lifetime in prison. This is an article in thenewamerican.com. Federal prosecutors prepared to make their case for keeping Dr. Hovind, the ministry's property. One of the U.S. government lawyers involved in prosecuting Hovind talks about it there. The other assistant U.S. attorney, Michelle Heldemeyer, was in the news in early 1990s after her husband was involved in a pedophile ring, and so they moved her from one part of Florida to another to avoid prosecution for her husband being in a pedophile ring. So there's a bunch on the internet. I suggest you look at both of these cases. There's all kinds of stuff on this topic, okay? There's a rule in baseball. If somebody hits a long ball and they run all the way around the bases, but they don't touch first, and somebody calls for a review of the play, and they look and say, whoa, sure enough, he missed first base. What happens? He's out and the run doesn't count. Well, the government missed first base with me and lots of other bases, okay? Now, this is an election year. I'd like you to ask all your politicians that you know or support to look into my case and to watch carefully how the judge responds to the motion she got last week. All documents will be posted on KentHovinIsInnocent.com, okay? Paul, I'm going to read this now and ask you to explain a couple of paragraphs here. This is filed in the U.S. District Court for the Northern District of Florida. Notice, this document cannot be used to create any form of jurisdiction over the man. Court administrator, judge, is to take judicial notice of all evidence of law and court rules herein incorporated. You have anything, if you want to interject at any time, Paul, just let me know, because you're the one that wrote this. Okay?
Sure.
Number three, no oral arguments, all responses, defenses, oppositions to this motion are to be in written form and presented before the court as the court so instructs. Motion to vacate. Now, what this means...
The reason we're doing that is so they don't play any games. The best debates are written debates where you receive a written item and you've got a week to think about it, and you write, so you got time to think about it. So written debates are by far a more accurate way to come to the truth of an issue. That's why we go with oral arguments. Go ahead.
Okay, number 4. Regarding the motion to vacate, no evidence of a Fourth Amendment verified complaint before the grand jury or in the official record as required. Listen, interesting. This is the whole gist of this particular motion to vacate. Hang on, my chair is slowly sinking here.
Sure. Let me comment on that. If you notice above, we have it as a man. Now, if somebody elects to become a United States citizen, you lose your status as a man. And there's court cases that says the Bill of Rights is not afforded to you. So during the trial, I was in court and I watched them try to get them to say that Kent was a U.S. citizen. And if he did say yes, now this last proceeding he didn't say that. He couldn't get that evidence on the record. But if he did say yes, see, then the Fourth Amendment does not apply.
Now, Paul, this sounds like it's coming from Mars to the average person. That when they say you're not a U.S. citizen, of course you are. Can you explain that in a little more detail? How do you become a U.S. citizen? Because most people living in America think they are.
Yes, and it's designed that way because if you do allow that to become evidence before the court in any way at all, they gain a tremendous amount more latitude in prosecution. For example, in this case, they wouldn't have to provide the Fourth Amendment. They can skip the sworn statement. They can just go out and they're persons that have become U.S. citizens. They can go out and arrest them much, much easier than they can a person that remains in the status of a American-born birthright.
And see, again, this is going to sound like it's coming from Mars, but American-born birthright is different than a U.S. citizen. There's only one way, if I understand it, to become a U.S. citizen. And how do you become one?
Yes, the law actually says that it's by oath and none other. The law actually says that word for word, by oath and none other. So if you haven't stood in front of a judge and a magistrate that's authorized to give the oath of citizenship and raised your right hand and repeated the oath after him, generally recorded by several cameras, because it's very important for them to keep that record.
Right.
That is a contractual relationship with the United States. So if an American can do it and a Mexican do it, it's war in Mexico.
Sure.
So you don't want to do that because some people claim that, well, I did that in the military somewhat. Well, that's a temporary contractual relationship in the military. But U.S. citizenship, it continues. So they don't re-enlist you in the United States system, much like they do in the military. But yes, it's a contractual relationship, and once the contract is in place, if it possesses full disclosure, and they're very good about giving full disclosure, then you actually waive your rights that are found in the Bill of Rights.
Okay. All right, number 4. This motion to vacate, what we're asking for is for them to vacate the case because no evidence of a Fourth Amendment verified complaint before the grand jury or in the official record as required. You asked them, you wrote to the court and said, can you please give me a copy of the verified complaint? And they wrote back and said there isn't one. Is that correct?
Yes, we asked them to, there's 2 reasons to have that there's 3 reasons to have a verified complaint on the record, or at least 2. The grand jury cannot just get up in the morning and decide to pick on somebody. A man has to fill out a sworn complaint. Now remember, I said a man, not a U.S. citizen. A man has to fill out a sworn complaint in his personal commercial liability in order to come after you. Because if it's all a lie, then you can go after that person and sue them and take their house away from them. So people are much less reluctant to try to destroy somebody. Like, you are a man that was his reputation is extremely important to him because you're spreading the gospel for God, and it's important for you to be. The Bible actually says that you're supposed to be without blame out there.
Right.
But anyway, it's required to prosecute a man. A sworn statement has to be brought to the grand jury. Now, there's another reason why a sworn statement, another word for it is affidavit, has to be brought into the record, is if they're going to seize anybody or anything. The Fourth Amendment requires that the sworn statement be in the record. That way, if the seizure takes place of somebody's property, somebody's car, somebody's house, or somebody's body, in your case, they arrested you. The Fourth Amendment is required to be there as a matter of law. The Fourth Amendment says that no warrant shall issue except by oath or affirmation. Not a single warrant can issue in America against a man without a sworn statement in the record. Somebody's got to put their personal commercial liability on the line to for the government to grab somebody's property or personage. Body.
Most people don't know that was the third grand jury. They convened 2 grand juries before to try to find something on me, and they both couldn't find anything. So the third.
Let me explain why that probably happened. The first 2, there probably was somebody on the grand jury that asked a simple question: is Kent eligible to collect taxes from any of these 40 workers of the church? Another question: is Kent Hovind qualified to collect taxes from anybody on the church ministry? And another question is: is Kent required to collect taxes or withholdings from any man in the church ministry? The question to every one of those would be no, no, no. Because if you study withholdings, it's very specific that you've got to qualify to withhold, and the people have to qualify to be able to actually withhold from them. Neither of those were evidence before the grand jury. They probably couldn't get an indictment because somebody on the jury was probably asking the IRS agent, any of those questions. But then the third time, what we believe happened is they just decided, well, let's just pretend like we had a grand jury indictment, and we'll just run it through, because we found that to happen in other cases across the nation, where they seal the record, all hush hush, and the foreman's name is blotted out, and guess what? They get an indictment on you. Now, the reason we found out about this, and the reason we were inspired to do this investigation, is that a client of mine was in the federal courthouse, and a federal judge walked up to him and he says, if you want to find out if there was a grand jury proceeding, order the court reporter's payment, because for every proceeding, a court reporter is paid to preside over that, because they're independent contractors. And the federal judge basically says, you don't know me, I never told you anything, have a good day, sir. So that inspired us to contact the court and ask if there's a Fourth Amendment sworn statement in the record. The court wrote it. We got the record. You can look on, Kent's going to put it up on the website for you, where the court wrote back and said there's no such document in the record. Now the court rule says it has to be there.
So regardless of everything else, even if I was guilty of everything they accused me of, which I was not, they didn't touch first base.
Yep, that's what it appears.
The run doesn't count. Start over.
Yep.
But there were some people on the previous grand juries, some people were called in to testify before that, and they came and told me, Kent, they're convening a grand jury against you. I said, for what? And they couldn't find anything. So the third grand jury, maybe the fourth, finally, the government just, I think you're right, I think they pretended they got an indictment, brother. And
it appears to be.
The whole case is...
There's no documents in the record.
All right, let me go on here. Number 5. The motion under Rule 60B is only utilized in the event that the defendant cannot seek the vacate as a man by right. Number 6. Federal Rules of Criminal Procedure, Rule 9. Arrest warrant or summons on an indictment or information issuance, the court must issue a warrant or, at the government's request, a summons for each defendant named in an indictment or named in an information if one or more affidavits accompanying the information establish probable cause to believe that an offense has been committed and that the defendant committed it. So nobody issued a complaint with their name on it, because then they would be, if an individual person, let's say an IRS agent, went in and swore out a complaint against me in his personal capacity, he then becomes liable. So nobody wanted to do that because they knew I hadn't broken any laws.
Yes, and they knew that they potentially could lose their house over it.
And they still should, and they still may, and they still should. Yeah.
And that's exactly right. The Bible says anything they tried to give you should be laid upon them now.
Yeah.
They tried to give you what? What did the prosecutor recommend the judge to give you? Do you remember?
They gave me 10 years in prison and seized all the church property and the church bank account.
Yeah, just horrible. Now, if you look at court rule there, it says if the summons can issue if one or more affidavits accompany the record. It says there has to be an affidavit in the record.
And there isn't one in my case.
Now I was talking to some police officers, and they said, absolutely, man, anytime you arrest somebody or go out and seize property, there has to be an affidavit involved. He said that's a very well-known fact among police. But go ahead.
Okay, rule number 7. Number 7, federal and local rules of appellate procedure, Rule 34, oral argument A. In general, the party's statement any party may file or a court may require by local rule, a statement explaining why oral argument should or need not be permitted.
No, we don't have to go through that whole thing, but that's just basically the oral arguments, because we're going to force them to be systematically and with transparency. See, if they write something up, we can take that document, we can put it on the website.
Sure. Number 8, I'll skip down to number 8. Defendant motions this court, we're asking the court to vacate all judgments, orders so associated with this case for the following reasons. Number 9, this document hereafter is an affidavit form. Number 10, that all arguments herein are based on facts that are directly germane to the captioned case as to time, location, as associated with the indictment. Number 11, that Kent E. Hovind, hereinafter as affiant, is not evidenced as electing to become a United States citizen. You're going to get all kinds of the moron, stupid atheists out there pick on this one right here. They don't understand.
No, the reason that line is in there is because we must give the court notice that you have the Bill of Rights protecting you. If you're a U.S. citizen, you don't have the Bill of Rights protecting you. But
correct.
You are a U.S. citizen. Go ahead.
I was born in Peoria, Illinois. Okay.
Now, a matter of fact, even if you said you were a U.S. citizen, that's not evidence that you're a U.S. citizen. They have to have a record of it. Go ahead.
I had to take the oath before a magistrate saying I would like to become a U.S. citizen.
Yeah, and even if you said you were a U.S. citizen, that doesn't make you a U.S. citizen. They have to have a record of you taking that oath properly, right. Yeah.
Okay, number 12. That affiant is not evidenced as a person that is not afforded the Bill of Rights as enumerated in the Constitution. Now, Paul, this is how they justify abortion. The Supreme Court in the Roe v. Wade case said the unborn child is not a person. This is trickery here. You don't become a person until you get a birth certificate. So the unborn child is technically not a person. What exactly is a person in law, Paul?
Well, any interaction with the United States is less than a man. So you can't, the United States cannot become a man and interact with you. So the man has to go to the level of the United States, which is a fiction in law. A corporation, for example,
right.
is a fiction at law. Just real simple, the United States cannot become a man, therefore the man has to become the United States to interact with them. So, see, with the United States, all relationships are contractual, even a crime. The United States courts have said crimes are a commercial activity because you have to interact to come to their level, to come to their commercial level as a person, not as a man. Simple. It's pretty simple.
All right, number 13. That affiant is a man possessing full birthright as a man in Florida land, as such land is not being seceded, owned, or purchased by the United States of America, as such land is identified in Article 1, Section 8, Paragraph 17, found in the Constitution of the United States. All right, Paul,
okay,
I'm sitting in Lenox, Alabama. Am I in the United States?
Well, you never say yes or no to that. You keep the burden of proof on the United States, because if you take on the burden, they'll just say prove it, and the judge will, they'll trip you up every way they can. But if you keep the burden of proof on them, they would have to produce a certified copy that the United States of America is the owner of record of the piece of land that you're standing on. Now, they might be, but I doubt it, because the United States owns very little land in Alabama. I'm up here in Omaha, and they only own 1.4% of Nebraska. I suppose it's only 1 or 2% of Alabama. Now you get over to the federalized states, because after the Civil War, the government started grabbing a tremendous amount of more land after the Civil War. So it went from 0.4% on the East Coast in Connecticut to 34% in California and 84% in Nevada. So, but anyway, you keep the burden of proof on them, and that's what we're doing here.
Well, it was very interesting. When I was in Berlin, New Hampshire, just about to get out of prison after serving all that stupid time, they tried to put another charge on me of mail fraud, which could carry a 20-year sentence. They said you mailed a letter to the courthouse. And they were trying to prove that I mailed the letter and that the letter went over the United States land. And so I followed that very carefully. They were trying to prove it went through a post office that was on U.S. land, because the post office rents a lot of their properties to build their post office. When I was in prison in Mississippi, what was the prison, the huge federal prison in Mississippi? I was just there for... Anyway, the mayor, the governor of Mississippi, Haley Barbour, owns the land that the government has a 99-year lease on to build the giant prison there in Mississippi. It has one of the largest prisons in America, and he's got a 99-year lease. So, of course, and his son, Haley Barbour Jr., is the chief federal judge in the district court in Mississippi, in the central Mississippi. Brain went blank here. Anyway, to me, that's just a conflict of interest, okay? Because of course they want the longer sentences they give, and the more people they sentence, the more sure their lease payment is on their land. So they were trying desperately to prove that the government owned land that letter went over. So they don't own the whole United States.
No. Now, years ago, a postal person told me this, that years ago, all the mail used to go over in Nebraska, used to go over this piece of land. Every piece of mail in Nebraska went over, I think, 2 locations, east half and the west half, 2 locations. So if the mailman wanted to just grab the envelope and just hand it to Bill standing right beside him, he couldn't do that. He had to ship it 100 miles to get it stamped in Omaha, Nebraska, and then go back to that little small town so he can stick it in that box right beside the. And I asked him, why is that? He says the federal government doesn't get jurisdiction unless it passes over federal land.
Exactly right. So
now they don't do that anymore. They don't do that because I think one reason they don't do it is because they have a terrible time competing with
FedEx,
UPS, for example. Efficiency reasons, they just don't move the mail around like they used to. But anyway, that's all. And then see, you have to initiate it. You have to have intent to have that property of yours go across the land. So that's another defense you have.
Well, they tried frantically.
Just because they run it across the land doesn't give them federal jurisdiction. You have to intend to do that. Go ahead.
Yeah. So in the Constitution talks about post offices. The government can own Washington D.C. 10 miles square, post offices and postal roads. But technically, I think there have been court cases where they only own the section of the road where the post office truck is actually driving at that minute. So as the truck drives across the road, they own the truck. So it covers 20 feet of road along like that. It's very interesting. That's off topic here, but the point is they never proved that I did anything on their land in this case to give them jurisdiction.
Yep.
Okay.
And they have to. They have to.
They have to. So number 13, they never proved that anything was done on the United States land. Okay.
Now let's just look at the case in 2006. One of those 40 workers that they claim that you were required to hold is evidence of doing activity where their written law has more effective law. They have to prove that.
Right. The way I explain this to people, if I'm walking across a gymnasium carrying a basketball and not bouncing it, I'm just carrying a basketball, can somebody walk up and charge me with violating a rule and say you're traveling? Well, that depends. If I'm on the court during game time and if I'm on the team, right?
Yes.
It's not
the rules of the game come into play.
Right. So the rules of the game come into play at certain times, on certain property, with certain people. And people just can't get that concept into their head. I don't want to play their game. I don't want to play with them at all. I was trying to do everything right. Okay, number 14.
Well, the federal government has become very much demonic. Evidence of that is abortion, a homosexual agenda. The family is being destroyed by the federal government. The list goes on. If God tells us to go right, the federal government almost always tries to push us left.
Yeah.
So it's bad. It's very bad, and the churches should be all over this. The churches, almost no churches, stood on your side. They all abandon you pretty much, and it's pathetic.
Yeah.
Pathetic. Okay.
All right. Let's finish. Try to get this all in here. Number 14. That affiant, that's me, is not evidence as electing to be a resident or one to reside in the United States. That's a question they often ask on all kinds of forms you fill out. Are you a resident of the United States? Explain how that is a trick question.
If you go into the statutes of the Lord, resident means government land. It's a trick.
So in other words...
Same way with the word county. County in the statutes at large, which is the law of the nation, is the federal government, not all the people, just the federal government. County means government land. So if you're in court and the judge asks you, were you speeding in the county, sir? And if you say yes or no, you're going to lose your case. But if you say I have no evidence in my possession, I was in land of the county, then the burden shifts to the moving party, and you're likely going to win your case because they don't have a witness to testify that you were on government land.
All right. It's all a big trick, a money-making racket. Okay.
Yeah, yeah.
And I don't want to spend my time fighting this stuff. I just want them to overturn my case, to pay the damages, and leave me alone. I want to go fight evolution. That's my calling. My calling is not to fight the IRS. I'm not a tax protester. I've paid every tax I owe all my life. Now, our country was started by a bunch of guys throwing tea in the harbor, which is protesting a tax. But so, I'd have been handing them a sandwich as they walk by, but I would not. That's not my calling to do that. Okay, number 15.
Yeah.
That affiant is not evidenced as one who did any business, contract, or any activity in land of the United States. Number 16.
There's land again. Go ahead.
Okay. That affiant requests the court clerk to send affiant a certified copy of the sworn complaint, affidavit, that the prosecutor used to proceed under. They didn't have one, did they?
Right.
So they missed first base.
It appears to me.
Game over. Overturn the case. Leave me alone. Number 17. That affiant was notified in writing that no sworn complaint that the prosecutor used to proceed under can be found in the case record. This is where they answered your letter and said, well, there isn't one. Right. Okay. Number 18. That there is no record of a sworn complaint, affidavit, that the prosecutor used to proceed under is in the official record, case record. There is no affidavit in the record that meets the requirements of Federal Rules of Criminal Procedure, Rule 9, as such rule is fully stated above in paragraph 7. Number 20. That affiant is protected by right of a man from prosecution or arrest without evidence by sworn complaint. You can't just go arrest somebody like they do in communist countries. Who exactly is charging me with doing what? When they came and arrested me, I said, what did I do? Structuring.
This is the interesting. See, the United States cannot charge you. Only a man, an agent of the United States, can charge you, and he has to do it in his own personal commercial liability.
Right. They don't want to do that.
No, they don't want to do it. Unless they know it's actually true.
Okay. Number 20. That affiant is protected by right of a man from sworn prosecution or arrest without evidence of a sworn complaint upon probable cause in this official case record according to the Fourth Amendment. So there isn't one. They didn't have that. So all we're pointing out, Paul and I, they didn't touch first. Judge, overturn the case. Simple. It's real simple. Now, Paul, this is just the first of many defenses. If they don't on this one, I'm going to go to the rest of my life. Brother, I didn't commit a crime. I want them to leave me alone and return everything they stole. Sweetly in Christian love. Okay? Number 21. That affiant was arrested when in land, his home, not evidenced as being land of the United States. Back to what we talked about earlier. They're supposed to prove this is our land and we have authority here. By U.S. Marshals, under a claimed indictment, in association with this captioned case, the administrator is asked to look to the record for additional proof of arrest. So you're asking the court clerk to look through the record and say, is there any other proof that they had this? And you've already asked them, and they said no.
Well, basically, just proof that you were arrested, and that's obviously going to be in there because they arrested you probably in front of for arraignment.
They arrested me with a SWAT team. They had 20 armed SWAT team members come storming into my house.
Yeah.
I was getting ready for Bible study, 7:30 in the morning. I'm sitting there, unreal.
Yeah, they do that to
intimidate,
destroy, to break the spirit of Americans.
Yeah.
They do that because most Americans are cowards. Cowards. They'll do anything to avoid that.
Yeah.
I don't care if they come in and aim a gun in my face. I've had that happen to me, an AK, whatever they have, 4 feet away from me, aim right in my face, and I just look right in there, and I don't even blink an eye. It doesn't bother me one bit.
Number 22.
But most people, okay, go ahead.
That there is no evidence that affiant waived any right, or that such a right can be waived as associated with the Fourth Article, the Fourth Amendment, as found in the Constitution of the United States. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizure shall not be violated. They violated it in my case. And no warrant shall issue but upon probable cause supported by oath or affirmation. This is straight from the Bill of Rights. But they went around this by claiming I don't have those rights because I'm a U.S. citizen instead of a man.
Well, we don't know. We don't know. But
it's burden of proof's on them.
Yeah, they have to prove that.
Okay.
And they have to prove it by documented record, because if you're a U.S. citizen, it's going to be in their records. They don't have it.
23. That affiant is not evidenced as being charged by sworn complaint by any claim of any man. So no particular man stood up and said, I claim Kent Hovind did this. Okay? Number 24. Affiant is not evidenced as being charged of doing any act in any state or district as required by the below Sixth Amendment of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, Sixth Amendment. Number 25. Affiant is not evidenced as being charged of doing any act in a district that has been previously ascertained by law. Same concept here. Number 26. Affiant has not been charged as a matter of law. So they missed first base. It is that simple. Number 27. Affiant has not been accused as a matter of law. Number 28. No evidence exists that a witness presented evidence associated with any criminal action to initiate a grand jury indictment. Number 29. That no man has given sworn evidence to the grand jury of this case that affiant is a person subject to any written laws of the United States. Number 30. No man has given sworn evidence to the grand jury of this case that affiant did any activity that is subject to any written laws of the United States. 31. That no man has given sworn evidence to the grand jury of this case that affiant did any activity in land of the United States, as described in Article 1, Section 8. And the case you gave here from the American Banana Company, construction of any statute as intended to be confined in its operation and effect to the territorial limits over which the lawmaker has general and legitimate power. I use this illustration. If I'm driving down Highway 84 to Monroeville and a Mexican police officer pulls me over and says, "You're speeding, sir," I don't argue how fast I was going. I simply ask him, "Sir, where's your jurisdiction?" You're out of your jurisdiction. You have jurisdiction in Mexico, not on Highway 84 in Alabama. And so, did they have jurisdiction? And the Supreme Court has ruled, of course, they don't have jurisdiction. They have to prove where their jurisdiction is, and they didn't do that. 32. There is no evidence that affiant is charged by any man as to any claim of committing a crime as associated with this captioned case. There is no evidence, no payment record, that a court reporter was paid to keep an official record of the grand jury, which again is against the rules, and they could overturn the case on that one.
Yeah,
30.
They know that if they don't throw this case, vacate this case, we're going to come back in on that also.
Right.
So, go ahead.
Number 34, that affiant wishes not to waive any rights as associated with any of the said Bill of Rights. Number 35, that the indictment of this case is not supported by sworn complaint, a Fourth Amendment due process violation, leaving the court in want of subject matter jurisdiction. So the court didn't have jurisdiction to even hear the case.
They had no jurisdiction to arrest you or require you to make a plea at the arraignment.
Okay. And lacking sufficiency of the pleadings, thus such indictment is void, and all subsequent actions, judgments, orders thereafter are void. Didn't happen. They missed first base. Void judgments are those rendered by a court which lacked jurisdiction, either of the subject matter or the parties. And they did not prove they have jurisdiction over the party, To get that, they have to have a man come in and make a complaint, an affidavit, and the grand jury, and they didn't do any of that. Okay.
And also, they don't have anybody attesting that the written law that they're relying upon operates at the location.
Okay.
They've missed everything.
Well, Brady investigated my case for 15 months. He said, Kent, they broke over 100 laws to put you in prison. I said, well, let's go back after on each one of those 100 until they overturn my case, pay me the damages, and leave me alone.
Why don't you skip all the way down to 14? I think we're...
Okay. 14 ALR Federal 298, that's the end right there.
No, 14, wherefore,
okay.
Kent Hovind, right above your signature, way down below.
Yeah, way down here. Wherefore, affiant Kent E. Hovind, the sign, motions this court now to vacate all judgments, orders as associated with this case, for the court is in want of subject matter jurisdiction. For the irrefutable due process violations as enumerated, sworn above as a matter of law and justice. And being that affiant is not an attorney trained in this court's procedures, if this document is not correct, to meet affiant wish that the presiding court administrator provide assistance to perfect the document. Because they look for some little, I not dotted or T not crossed. Okay, and then I signed it and sent it in, and they got it on the 31st, 5 days ago. And so the motion to vacate was received at the court, time-stamped, and sent certified mail. And I am healthy, happy, not suicidal. I'm accident-free. For many years, I drive vehicles that have no known mechanical problems. I take vitamins, and I plan to live to be 100 or die trying. Perfectly healthy. So if I disappear, everybody go investigate this one. Okay? Any questions from the crowd here? Or Paul, anything else to say?
Yeah, let me say, just recently I've been working with an individual that has a very similar case to this. And he had two, if I understood it right, he had two retired federal judges helping him with it, and two attorneys. And let's see, that's four. And another guy, and then himself, and then one other person. 7 people total. In 6 months, 5 of those people have died. This is serious stuff.
It is serious stuff.
Serious stuff.
Because they know we are exposing a gigantic scam, a money-making racket that they've been doing for decades. And again, I don't want to fight them. They came after me. It's like this moron Dan. He started a fight with me, whack an atheist, I didn't start a fight with him.
Now, the law firm that has taken his case recently just got audited by the IRS.
Well, they should be worried that they'll be exposed. But that's not my job to go around exposing all the evils of the IRS or the U.S. government. That's not my calling in life. I just want to whack an atheist. I think it's fun. I think I'm good at it. I'm really having a blast doing it. But they came after me. They seized everything. I want them to... Do they ever say they're sorry, or do they just return the property and leave you alone?
They tax the heck out of people and give you their money.
Okay.
Damages.
All right.
So,
do you want to give a number where people can contact you, or an email or anything if they want your help on something? I don't want you to help anybody else till mine's finished, though.
No, if anybody has any input on this, there's lawyers out there that listen to this presentation. They can go to the website, look at the documents very thoroughly. They're welcome to call me at 251-362-8231. That's my cell number. You can call it 24/7.
Okay.
Text me is the best way to get me to call you back.
All right. Well, you've been a blessing, brother. Come visit Dinosaur Adventureland. I understand it's going to be 32 degrees tonight up there in Omaha. It's going to be chilly.
Yeah.
So, all right.
It's about 42 in the daytime, 32 at night. I'm heading to Miami here, so maybe I'll swing by.
Okay. Sounds Bye-bye. Great. Thank you, brother. All right. Bye-bye. All right, folks. You atheists, now listen very carefully. Read my lips. I did not break any laws. I was unjustly imprisoned. Stop calling me inmate number 06452-017. Stop calling me a criminal and a tax protester. Start dealing with the real issues. Your theory of evolution is stupid. Real stupid. Oh, I'm sorry. We'll work on that tomorrow night. All right. See you tomorrow. Thank you. Bye.